Hello, I'm Jason Sullivan of the Rathbone Group, and this is On Subrogation. Today's topic is Alternative Dispute Resolution, or ADR. You engage in ADR anytime you negotiate or compromise a claim without using the court system. Anytime there's a negotiation where you don't file a lawsuit, that's considered ADR. There are two really other common scenarios that you may be familiar with as well: mediation and arbitration. Mediation is when there's a dispute between two parties and they bring in a third party neutral to help them negotiate and compromise on the claims. Frequently, this happens by putting one party, the plaintiff, in one room, the other party, the defendant, in the other room, and the mediator will go back and forth, hearing the arguments, what the parties feel are compelling about their case, why they think the other case is not as strong, and the mediator will pass that information back and forth. As opposed to being a confrontational face-to-face negotiation, the mediator helps facilitate the transfer of information and allows the parties to hopefully consider both the strengths and weaknesses of their cases and ultimately bring the case to a conclusion. Arbitration is similar in that you do bring in a third-party neutral. It's different because it is more like a regular civil trial court system. In an arbitration, the arbitrator, either a single person or a panel of arbitrators, will hear the evidence of the parties, but then, like a judge or jury, they make a decision on the merits of the claim and the value of any damages if they're to be awarded. Arbitrations can be either binding or non-binding, and the parties, both the plaintiff and defendant, agree on whether it's going to be binding or non-binding before they start the process. The advantage of a non-binding process is it allows the parties to not resolve the case and not hold themselves to that arbitrator decision. A binding arbitration, the parties agree to be bound by the outcome no matter what it is. Frequently, this makes it more difficult for a party that's concerned and wants to preserve the right for appeal, but it does provide finality. In the subrogation world, you may be really familiar with Arbitration Forums. Arbitration Forums is a private company that provides a platform for insurance carriers to bring their claims against other insurance carriers that have agreed to be bound by the rules of arbitration forums. In these cases, both insurance companies have to be signatories. If they're not both signatories, the party that's not a signatory can't be bound. Now, parties can agree to be bound on a particular case, but they are encouraged to, if they're going to use the forum, be members for all of their claims, usually regarding auto cases, but there's also property forums, PIP forums, MedPay forums, and special forums that address unique situations when there's maybe coverage disputes or secondary questions as to which carrier owes the primary obligation. With all things with the arbitration, the mediation, or the negotiation, the advantages and why companies are interested in using it are it's both a cost saver potentially and a time saver. On a cost perspective, if you're defending a case and have to hire an attorney to represent your interest, that may be quite expensive, especially if it's prolonged litigation that takes several years to go through. These arbitration or mediation confine the amount of time that you have to hire outside counsel to defend or to pursue your case. From a time perspective, the court system in the United States is frequently backed up depending upon what area of the country and what jurisdiction you're in. As opposed to having a case filed and not expecting to have it heard for maybe 2 or 3 years from the date of filing, a mediation or arbitration allows you to present your case in a much shorter time frame, sometimes just weeks or months after you request to have the mediation or the arbitration. That time saving, allowing you to move through the case, can be extremely valuable depending upon what the issue is. So whenever you're handling a subrogation case, a good thing to think about before you file a lawsuit is there an alternative dispute resolution that may be available? If you've tried negotiating, do you want to try mediating or maybe arbitration through arbitration forums or a similar venue would be appropriate? In those instances where they're not, it may be beneficial to have an attorney representing your interest. But again, from a time and cost investment, these are usually much quicker and require less involvement. And so you save money in resolving your claims this way. And at the end of the day, when you're trying to recover money, the less you spend to get that money back, the better the net back is for your company. I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. If you have any questions, please email us at video@rathbonegroup.com. Thank you very much.